I was planning on talking about today is prosecutorial misconduct. And the prosecutor in the criminal legal system is absolutely the most powerful person. The prosecutor decides whether someone will be charged with a crime or not. And if they are charged, whether it'll be serious or not serious or more serious. And they decide whether or not to make a plea agreement with someone where they can plead to a less serious charge and receive a less serious penalty. And that is just an enormous amount of power. They're supposed to be bound by a code of ethics. In New York, those are the rules of professional responsibility. And those rules are violated time and time again and have been for a very long time. So what I'd like to talk about today is the history of those violations and the work to try to deal with the people who commit those violations, starting way back in New York history, coming to the present, and then looking forward to some of the things that people are trying to do now to advance the cause of dealing with prosecutorial misconduct. So to start way back, in 1741, New York City was a small town, mostly on the southern part of Manhattan Island. And there were a significant number of enslaved people there, African slaves. About 15% of the population were enslaved people. And two events happened in March of 1741 that precipitated a series of slave conspiracy trials where hundreds of Black people were arrested, charged with participating in a conspiracy to foment a slave revolt. 13 of those people, 13 Black men, were burned at the stake in Lower Manhattan, in a place right behind where the criminal courts are now. 17 Black men were hanged. Over 80 Black people, men and women, were transported into the slave plantations in the Caribbean. 4 white people were hanged also. And in part, that was because, as the Attorney General said at the time, it was inconceivable that Black people could think up a revolt plan by themselves. They just didn't have the intelligence. So they had to find a couple of white people to blame also. Now, 2 events happened in March of 1741 that came together to create the basis for this horrible, horrible murder under law of dozens of people. The first was caused by one man, a slave by the name of Quack, who had a wife named Barbara, and they were both owned by different people. Barbara was owned by acting Governor Clark, and acting Governor Clark lived in a mansion inside Fort George at the southern end of the island. When Quack's work was done for the day, his owner would let him go and spend time with his wife, Barbara. But Governor Clark thought that Quack was a nuisance and was getting in the way of Barbara doing her work for him. She was his cook. So he banned Quack from coming to the fort and coming to his house and seeing his wife. On the one hand, this is really a lot about what slavery was about. People didn't even have the right to have a marriage, to have a family. It was all in the power of the slave owners. But Clark was really pissed off that Clark wouldn't let him see his wife anymore. So he set fire to Clark's house. And most people came and tried to help put the fire out. At least one guy named Arthur Price, who was an indentured servant, got busted because what he was doing when other people were trying to put the fire out, he was trying to steal stuff from Clark's house. And this is a white man who was an indentured servant at the time. And he got busted for stealing stuff from the burning house. And he gets put in the jail in City Hall. The other thing that's happening at the same time is there's a tavern, for those of you who are familiar with Manhattan, near Trinity, above Trinity Church, north of Cortlandt Street. And that tavern was owned by a man named John Hewson. John Hewson ran the tavern with his wife, Sarah, with their daughter, whose name was also Sarah, and with their indentured servant, a 15-year-old white girl named Mary Burton. And Hewson catered to the poorer people in the town, to Irish soldiers from the fort, the British fort, to other indentured servants, and to slaves who were able to go and had some money. Now, how did slaves have money? They weren't allowed to have money. But the thing about John Hewson was he was also a fence. He bought and sold stolen property. So if people, enslaved people or indentured servants or anybody else stole some stuff, they could bring it to Hewson and he'd give them some money for it. For the slaves that did that, they then spent the money they got from Hewson in his tavern. So they were a captive clientele of John Hewson because they couldn't go anywhere else to spend the money they got from him. One of the burglars was a man named Caesar. And Caesar was a longtime client of Hewson. He was a burglar. He stole stuff at night when he wasn't doing his job as a slave. And he and some other slaves would create crews and do various burglaries. One of those burglaries, the people, not the cops, and not law enforcement, but a number of women who were the victims of the burglary and were the neighbors of the victims of the burglary, had suspicions about who committed it. And they confronted Mary Burton, and Burton was Hewson's indentured servant. And she gave up the truth that Caesar had been the one who had burgled this woman's store, and that had brought the proceeds back to Hewson's tavern, and had even given her a gold coin that was part of the proceeds, because she was part of the operation. So that's what she got out of it. So Caesar gets arrested, and the Hewsons get arrested, and Mary Burton gets arrested because she's part of the operation. So Mary Burton and Arthur Price, the two white indentured servants, are sitting in the jail in City Hall, and a couple of other fires get set. A member of the governor's council said that he thought what was going on is people were setting some fires in order to do what Arthur Price did, to create a cover to be able to steal things. But Price and Burton are now stuck in jail, and they're looking for a way out. So they come up with a plan. Price goes to the jailer one morning and says, Mary Burton confided to him that these fires were all being set as part of a plot by slaves that had been set at a Christmas party at Hutchins Tavern to destroy the colony of New York, to kill all the white men, to marry all the white women, to make Hudson the king, even though he was white, and Clark, Quack, and Caesar the governors, and that they were going to take over the town. And that's what was really going on, was a slave revolt. And they started arresting people. They see black people on the street. White people would just start going after them. Black people would run away. And just like with traffic stops today between black motorists and white cops, one person running for their life is proof of guilt to the other. So literally over 200 black people are arrested, and people are tortured, And they're also told that the only way they can save their lives is by not only confessing, but admit who else was there when this plot was hatched. The people that initially get arrested, Quark and Caesar, and several others are burned at the stake. And now they can say to all these other people, all these other enslaved people, unless you confess, you're going to wind up like them. And they leave the bodies, the burnt bodies and the hanged bodies, all out for everybody to see, rotting in an island in the Collect Pond behind what is now the criminal courts in Manhattan. So people, to save their lives, say, okay, I confess, so please don't kill me. And they get 80 coerced confessions where people would name themselves and then name other people. And then those people would be brought before Mary Burton. And Mary Burton, in every case, would say, yes, I remember that person was there too. And the people that she said were the ringleaders and more important would be either burned at the stake or hanged. But because they couldn't believe that it could just be a bunch of black slaves that would think this stuff up, they hanged John Hewson, they hanged his wife, Sarah. They arrested an Episcopal priest who was teaching Latin and Greek in the colony. And they were suspicious of him because he taught Latin, which was the language of the Roman Catholic Church. And at the time, to be a Jesuit priest in New York was a capital offense. So just for that, you could be hanged. But he was charged with being a Jesuit and a leader of this conspiracy. It was completely fabricated. People testified that, in fact, he was a member of a dissident Episcopal sect. He wasn't a Roman Catholic. He didn't do any of the things that were alleged, but they hanged him too. There was a black doctor known as Dr. Harry, who had moved out to Nassau County the year before any of this happened, but he was named too. They brought him in. He couldn't possibly have been part of it. He was living in Nassau, and he wasn't commuting to the city like a lot of you might do or did. He was living and practicing in Nassau, but he was a black doctor. He was a free black man, and he was considered a dangerous person just by virtue of that. They hanged him too. He wouldn't confess. He said, I had nothing to do with this, and you can't get a coerced confession out of me like you did out of the others. The part of how I got interested in this was that two of the main prosecutors were John Chambers and Joseph Murray. And for many years, I got off the New York City subway train at Chambers Street to go to work. And Chambers Street and the street just north of it, Murray Street, are named after John Chambers and Joseph Murray. And they were the two primary prosecutors of these cases that resulted in all these innocent people being killed. And most people commute to work, they get off, or commute to Stuyvesant High School, they get off the subway train there. They have no idea who John Chambers was. So I thought it was worth writing about. And I wrote an article, which if you're interested, you can read the longer article, longer than what I had to say today, which is in the 2024 winter edition of Atticus magazine. So that gives us some sense of the power of a prosecutor, and it gives us some sense of how awful what they could do was. Let's fast forward to our current day. I was the attorney in charge of Legal Aid's Capital Defense Unit starting in 1995 when New York brought back the death penalty. And one of my colleagues who worked for the State Defender Office, State Capital Defender Office, Mitch Dinnerstein, was representing a man named George Bell, and George Bell was charged with capital murder in Queens. And he was charged along with two other individuals, Mr. Bolton, Mr. Johnson. They weren't charged capitally, just George Bell was, because they said he was the shooter. As it turns out, they sought the death penalty in that case in Queens. And the two assistant district attorneys, Testagrossa and Leventhal, in fact knew that George Bell was innocent. They knew who the real killers were. They had police reports that said that a gang called Speed Stick had committed this double homicide of an off-duty cop and a check cashing place owner. They knew all that. Testagrossa's handwritten notes were on the detectives' reports that showed that it wasn't George Bell who did this. And that we have a rule in the United States called the Brady Rule, which is also an ethical rule for prosecutors. It says they have to produce and give over to the defense anything that would show that someone's not guilty. Anything that would make a sentence less, but certainly anything that would show that someone's not guilty. They buried that information. They buried that information for 22 years. And I submit to you that that's the kind of thing that happens time and time again. And in most cases, we never find out about it. But after litigating and fighting and appealing and bringing a civil suit, after 22 years, the truth finally came out. That they had asked the jury to return a death sentence against someone they knew was innocent. To my mind, that's attempted murder. That's a serious crime. And it's consistent with the kind of stuff that Chambers did back in 1741. There's a straight line that goes from Chambers and Murray to Testagrossa and Leventhal in the 1990s here in New York. Testagrossa at the time, 22 years later, now we're talking about just 2 years ago, was the second in command of the Nassau County DA's office, and he was forced to resign. And Leventhal was the head of the Homicide Bureau in the Queens DA's office, and he was forced to resign. But neither of them faced any disciplinary charges for their misconduct. And they both, according to letters that their lawyers have filed with the court in civil litigation, said that the ethics board, the grievance committee set up by the court to deal with ethics violations, cleared them both, even though a judge had found that they were completely knowingly responsible for trying to seek a death sentence against someone they knew was innocent. And that is consistent with what we've found in others, many, many other cases. 3 years ago, a group of law professors in New York and Civil Rights Corps brought over 50 complaints against prosecutors for just this kind of misconduct. And to this day, not one of those 50 complaints has resulted in any kind of finding of misconduct. I'll just give you two other examples of the kind of misconduct we've seen. One was, one was Kyle Reeves, who was a DA in Brooklyn. And he and a detective who's now fairly famous named Scarcella, because a lot of Scarcella's cases finally got reviewed and were overturned, not because of what the DAs did in the case, but because of what the Detective Scarcella did. In a particular murder case, what they did is they fabricated an identification. How do you fabricate an identification? Well, they arrested a man for participating in a in a robbery and a murder. The defendant's name was Martinez. They arrested him. They charged him with murder. They had a lineup. They brought in a woman who was a witness to this robbery and murder. And she lived in the same building as Mr. Martinez. So she'd known Martinez for years. She'd seen him coming in and out of their apartment building for years. They put him in a lineup. He's number 3. They say to her, this is Detective I'm sorry, this is the detective, says to her, do you see anybody in the lineup that you recognize? And she says, yes. And then he says, what number are they? And she says, number 3. And he says, well, thank you very much. That'll be all. And she leaves. A week later, she's called to the grand jury to testify. And she says to the assistant district attorney in the grand jury, she says, wait a minute. That guy, Martinez, had nothing to do with this robbery. I was just asked whether I recognized anybody. And he lives in my building. So I said yes. And I said he was number 3, but he had nothing to do with this. And the DA in the grand jury writes this all down. They never turned that piece of paper, that document, over to the defense attorney. They put the police officer, the detective takes the stand and says that she identified Martinez. Well, she did identify him, but she didn't identify him as somebody who participated in the crime. And he's convicted, and he's sentenced to many years in prison for a murder that he didn't commit. And that takes years and years. They bury it. And again, it takes an incredible amount of fighting and litigation to bring that out and get Mr. Martinez out of jail. Another case happened in Manhattan, back where the original 1741 case happened, where the DA fabricated a confession. She and the detective go to see the person who becomes the defendant, who's in jail for, he's arrested on something else. And they say, were you there when the shooter in another murder case was told to go and find this person who had beat up one of the drug dealers, street sellers? And he says, yeah, I was there. They hired this guy to go and beat up the guy who beat up the drug seller. And there's a detective with the DA. And she tells the detective, don't write down anything he said. And she doesn't record it. Confessions are almost always recorded, and detectives almost always have to file a report. Their rules tell them they're supposed to file a report. The DA says, don't file a report on what he said. The person who was hired to beat up the guy wound up shooting and killing the victim. If the defendant was knowingly involved in something where he thought someone was going to beat up, that's not such a serious crime. If he was involved in something where he knew someone was going to be murdered, that's a much more serious felony. That assistant district attorney then is made a judge. And when she's a judge, when the case comes to trial, she testifies at trial that what he confessed to was that he knew that this was supposed to be a murder, and he's convicted and sentenced for the more serious charge. And that also took years and years to be reversed and come out. And that's the kind of misconduct that we've dealt with for many years. About 12 years ago, because of so much lack of accountability by prosecutors for this kind of misconduct, a movement started in New York to start a commission on prosecutorial conduct. just to deal with prosecutors because the grievance committees were not doing anything. In the history of New York State, there have only been 4 prosecutors who were ever sanctioned, that is suspended. No one was ever disbarred, but there were only 4 who suffered a suspension of their license for some period of time because of in-court misconduct. Excuse me. So a movement started to get a special commission to deal with this 12 years ago. And the District Attorneys Association fought it and fought it and fought it, but it passed the legislature. Republican-controlled Senate voted for it. The Democratic-controlled Assembly voted for it. Then Governor Cuomo signed it into law, and the DA's Association sued. They sued, they said, you've given it too much power. It can't have the power to discipline prosecutors. Only the grievance committees can because they're part of the court. And they won. So they had to come up with a new bill. A new bill came forward, and this time it just said that this commission would make recommendations to the grievance committees. They wouldn't actually be able to discipline the grievance committees. They'd make recommendations. And that passed constitutional muster, but it still had problems, and the DA's Association still fought that bill. So that got knocked out. And for a third time, the legislature passed a bill allowing the commission. And the commission had to be staffed by 11 members that would be equally divided between former prosecutors, former defense attorneys or current defense attorneys, excuse me, and former judges. The governor was supposed to make her appointments for a year and a half. She didn't appoint anybody. So the commission couldn't function because the governor didn't make her appointments. We started a campaign to get the governor to make her appointments. Finally, she made her appointments. I'm sorry, excuse me, the pollen is just terrible this time of year. Eventually, they finally have almost gotten started, and now they've come out with their rules and regulations that they've proposed, and those are now in a period where we're supposed to be commenting on them. The head of the minority in the Senate, that is the Republican leader in the Senate, never made his defense attorney appointment when this whole process of drafting the rules was going on. Now it was 3 years since the bill was passed and signed into law, and he still hadn't appointed the defense attorney that the law said he shall appoint. So we threatened to sue. And he finally made the appointment, but he made the appointment after they had drafted their proposed rules, which meant there was an imbalance of prosecutors and defense lawyers on the commission when they proposed their rules. And the proposed rules include one that says that only current prosecutors shall be subject to the commission. Now, that's completely contradicts what was in the enabling legislation. And it also means that all the people that I just told you about, the Manhattan ADA who became a judge, the 2 ADAs in Queens who are no longer ADA, assistant district attorneys, none of these people would be subject to the commission. And because of what we talked about before, what are Brady violations? That is where information is withheld, exculpatory information that would prove that someone is innocent, has been withheld and kept secret for years and years and years. And in many of these cases, the assistants have left the offices. They're no longer prosecutors now. They're in private law firms going about, making money and practicing law and not being held accountable for what they did 5, 10, 15, 20 years ago. Under this proposed rule, they won't be held accountable. Testa Grosser and Leventhal claim that the grievance committees have already cleared them of what they did in Queens to George Bell. And under this proposed rule, our new commission wouldn't be able to even take up their case. So this fight continues. So when we talk about the future is a continued fight to hold prosecutors accountable for the bad, really bad stuff that they do. And we are continuing that fight. Thank you.